Let me start with this, and I need you to really hear it. What just happened at the Supreme Court is not just about Donald Trump. It's not even just about presidential immunity. This is about whether the United States still believes in the most basic promise of its democracy, that no one is above the law. And legal historians are going to be studying this moment for decades, because inside that courtroom, something fundamental shifted. Now, I want to be crystal clear right from the beginning. What I'm about to explain is not speculation. This analysis is based on the actual oral arguments before the Supreme Court, the questions the justices asked, the answers the lawyers gave, and the constitutional precedents that shaped the entire discussion. This is the Supreme Court telling us in real time how it views presidential power, criminal accountability, and the limits of executive authority. And if you think this only affects one politician, you're missing the bigger picture, because the implications reach into every current criminal case, every future presidency, and the meaning of accountability in American law. So let's walk through what actually happened in that courtroom and why legal experts across the political spectrum are calling this one of the most consequential constitutional showdowns of the modern era. Here's the background you need. The question before the Supreme Court was simple to ask but explosive to answer. Does a former president have absolute immunity from criminal prosecution for actions taken while in office? That question didn't come out of nowhere. It exists because Donald Trump is currently facing multiple criminal prosecutions across different jurisdictions, federal and state, involving allegations tied to efforts to overturn the 2020 election, the handling of classified documents, and other conduct. Trump's legal team made a sweeping argument. They said that if a former president can be criminally prosecuted for official acts, then every future president will govern in fear that political opponents will come after them the moment they leave office. In their view, allowing criminal prosecutions would cripple the presidency itself. They warned of a future where presidents hesitate to make hard decisions, military decisions, national security decisions, because they might one day face criminal charges. In other words, they weren't just defending Trump. They were arguing for a version of the presidency that is shielded from criminal law entirely. On the other side, the federal prosecutors, led by Special Counsel Jack Smith, argued something far more fundamental. They said the presidency does not come with a get-out-of-jail-free card, that if a president commits crimes, they must be held accountable just like any other citizen, and that the Constitution does not anywhere grant criminal immunity to the president, former or otherwise. So the Supreme Court stepped in. And what happened during oral arguments tells us far more than the final written decision ever will. Because when justices ask questions, they're not just being curious, they're revealing their concerns, their doubts, their limits. And very quickly, Trump's claim of absolute immunity ran into serious trouble. One of the most revealing moments came from Justice Ketanji Brown Jackson. She didn't dance around the issue. She went straight to the heart of it. She asked, in essence, if we accept your theory of absolute immunity, does that mean a president could order the assassination of a political rival and never face criminal consequences? The room went quiet. Trump's attorney hesitated. Then he tried to say that such an act would be unofficial and therefore not protected. But Justice Jackson wasn't buying it. She pushed back hard. She asked, how do we draw that line? If a president uses the powers of the office and the military law enforcement executive authority to commit a crime, how is that unofficial? And that's where the argument began to collapse. Because the moment you say criminal acts are unofficial, you've admitted something crucial. You've admitted that immunity cannot be absolute. And once immunity is not absolute, the entire theory changes. Justice Jackson's questioning exposed the central flaw in Trump's argument. If immunity only protects lawful acts, then it protects nothing that needs protecting. Lawful acts aren't prosecuted anyway. That exchange alone signaled that the court was deeply skeptical of granting blanket criminal immunity to presidents. But it didn't stop there. Justice Brett Kavanaugh, often viewed as a strong supporter of executive power, raised his own red flags. He pointed to existing Supreme Court precedent. In the Nixon era, the court ruled that presidents are not immune from civil lawsuits and not immune from subpoenas in criminal investigations. So Kavanaugh asked the obvious question, why should criminal immunity be different? Why should the most serious form of accountability, criminal law, suddenly disappear at the doors of the Oval Office? Trump's attorney argued that criminal prosecutions are uniquely dangerous because they can be weaponized politically. But Kavanaugh reminded everyone of something the framers deeply feared: kingship. The Constitution was written specifically to prevent the concentration of unchecked power in one person. And granting criminal immunity, he suggested, would move the presidency dangerously close to the very monarchy the founders rebelled against. That moment mattered. Because when a justice like Kavanaugh signals discomfort, it tells us that the court is not inclined to bless unlimited presidential power. Chief Justice John Roberts also revealed the court's balancing act. He pressed the prosecution with a concern many Americans share. If there's no immunity, does that mean every former president will be prosecuted by their successor? What stops the justice system from becoming a tool of political revenge? The special counsel's response was straightforward: prosecutorial discretion, grand juries, judicial oversight, professional ethics. Most presidents don't face prosecution because most presidents don't commit crimes. And while Roberts remained cautious, it was clear that even he was not persuaded by the idea that the presidency must be insulated from criminal law entirely. Now, here's why all of this matters. The Supreme Court has not issued its final ruling yet. But based on these oral arguments, legal analysts overwhelmingly expect the court to reject absolute immunity. That does not mean the court will say presidents have no immunity at all. More likely, the justices will carve out a middle ground, protecting core constitutional functions while allowing criminal prosecutions for actual crimes. And that distinction changes everything, because once absolute immunity is off the table, accountability comes back into play. And with it, the principle that no office, no matter how powerful, places someone beyond the reach of the law. This is not about punishing presidents for policy disagreements. This is about whether criminal conduct can be ignored simply because it occurred behind the seal of the presidency. And based on what we saw in that courtroom, the Supreme Court is preparing to answer that question with a very clear message. Presidents are powerful, but they are not kings. Now let's talk about what this actually does in the real world, because this is where theory turns into consequences. If, as expected, the Supreme Court rejects absolute presidential immunity, the legal roadblocks holding up Donald Trump's criminal cases begin to fall away. And that's not speculation, that's procedural reality. There are 4 major criminal cases at issue. The first and most consequential is the federal case in Washington, D.C., tied to efforts to overturn the 2020 election. This is the case brought by Special Counsel Jack Smith, charging conspiracy to defraud the United States and obstruction of an official proceeding. That case has been frozen in place while the immunity question worked its way up to the Supreme Court. If the court says there is no absolute immunity, Judge Tanya Chutkan can immediately move to reschedule trial proceedings, and she has already signaled she's ready to move fast. The second case is the federal classified documents case in Florida. This one involves allegations that Trump retained highly classified materials after leaving office and obstructed the government's attempts to retrieve them. That case has been slowed down for a variety of reasons, including disputes over classified evidence and unusually favorable rulings for the defense, but immunity has still been a central argument. Once immunity is rejected, that argument evaporates. The third case is the Georgia RICO case brought by District Attorney Fani Willis, involving alleged efforts to overturn the election at the state level. That case has its own complications, including questions about prosecutorial conduct, but the charges remain active. And the fourth case, the New York Business Records case involving hush money payments, is already moving forward because it involves conduct that occurred before Trump was president. Immunity never applied there in the first place. Put all of that together, and you're looking at a historic reality: a former president facing multiple criminal trials, possibly within the same year. That has never happened before. But here's the key point that gets lost in the noise. What makes this unprecedented is not that Trump is being prosecuted. What makes it unprecedented is that a former president is facing credible allegations of criminal conduct supported by grand jury indictments. Plenty of powerful people have been prosecuted before: governors, senators, cabinet officials. The presidency does not confer lifetime immunity, and the Supreme Court appears poised to make that unmistakably clear. Now, let's talk about the argument Trump's legal team is pivoting toward. They're not just saying we should be immune. They're also saying even if we're not immune, these prosecutions are illegitimate because they're political. And on the surface, that argument resonates with a lot of people. Prosecutors are political actors. District attorneys are elected. Special counsels are appointed by political administrations. So how do we separate justice from politics? Here's how the system actually works. Prosecutors don't convict people, juries do. Before any of these cases moved forward, grand juries made up of ordinary citizens reviewed evidence and voted to indict. Judges reviewed those indictments and found probable cause. Defense attorneys had opportunities to challenge them and largely failed. Political bias alone is not enough to dismiss a case. You have to show selective prosecution, bad faith, or lack of evidence. So far, courts have consistently ruled that these cases meet legal standards to proceed. Now let's address the fear Trump's team keeps raising, the idea that rejecting immunity will unleash a wave of politically motivated prosecutions against every future president. That argument sounds persuasive until you examine the facts. Other presidents have left office without facing prosecution because there was no evidence of criminal wrongdoing. The standard is not political affiliation. The standard is evidence. If future presidents commit crimes, they should be held accountable too. That's not political warfare. That's the rule of law doing its job. Now, here's where things get truly complicated and, frankly, dangerous. Donald Trump is currently running for president again. If he wins the election and takes office in January 2025, the legal landscape changes dramatically. The Department of Justice has a long-standing policy, not a law, but a policy that a sitting president cannot be indicted. That policy exists to prevent interference with presidential duties. But what happens if someone is already indicted or even convicted before taking office? There is no clear precedent. That question would almost certainly end up back at the Supreme Court. There's another issue. If Trump were to return to office, he would have the power to direct the Department of Justice. He could order the federal cases dropped. He could attempt to pardon himself, something no court has ever ruled definitively on. He could effectively erase the federal prosecutions with the stroke of a pen. What he could not do is stop the state cases in New York and Georgia. Those are outside federal control, and that's why legal scholars are deeply concerned. Because even if the Supreme Court rejects legal immunity, a presidential election could still create political immunity. In other words, winning power could become a way to escape accountability. That's a reality the framers feared and tried to prevent. And this brings us to the heart of the moment we're living in. We are watching the legal system and the political system collide. The legal system is saying there is evidence. There must be accountability. The political system is saying let voters decide, not prosecutors. Both impulses exist in a democracy. The Supreme Court's likely ruling is not choosing sides politically. It's choosing a principle. That principle is that the law applies to everyone, including presidents. Justice Sonia Sotomayor captured this perfectly during oral arguments. She posed a chilling hypothetical. What if a president ordered the military to stage a coup to stay in power? Under your theory of immunity, could that president ever be prosecuted? Trump's attorney again said that would be unofficial. Sotomayor dismantled that claim. If criminal acts are automatically unofficial, then immunity only protects lawful conduct. And lawful conduct doesn't need immunity. In other words, absolute immunity collapses under its own logic. That exchange may end up being one of the most quoted moments of this case because it reveals the truth at the center of the debate. Immunity cannot exist where accountability must, and accountability cannot exist if power is unchecked. That's why this ruling, when it comes, will be remembered, not because of Donald Trump alone, but because it answers a question the Constitution left unresolved. Can a president be held criminally accountable? Based on everything we've seen, the Supreme Court is preparing to say yes, not easily, not casually, but necessarily. Because if presidents were above the law, democracy would be optional. And when the law becomes optional, power becomes absolute. That's not America. That's exactly what the framers were trying to prevent. This is a historic moment. And whatever happens next, in courtrooms or at the ballot box, this ruling will shape the presidency for generations. The rule of law is not about one man. It's about whether the system still holds. And soon the Supreme Court is going to tell us.